Hi, I'm Marynelle Wilson, an IP attorney at Cloudigy Law, and I see intellectual property issues everywhere I go. With the Olympics having just wrapped up and the great weather outside, I thought it'd be really fun to talk about some IP cases in the sports and fitness world and another one that deals with athletic gear. So let's get to it. Okay, this case is about Bikram yoga and copyrights. You might be familiar with Bikram yoga. It's also known as hot yoga because they heat up the room to 105 degrees to increase sweating as a health benefit. The founder of Bikram yoga is a guy named Bikram Chowdhury, and he designed a set series of 26 poses that you do over the course of 90 minutes that are intended to be the best type of yoga for your health. He, in fact, got a copyright on this series, and he teaches it in every class. Now, some of his students have taken this series and opened their own studios, and he has taken it upon himself to sue his former student for copyright infringement of his series. That happened last fall. This June, the Copyright Office changed its position on whether yoga flows are actually copyrightable. It said that yoga flows, like other exercise routines, are not actually creative the way that choreography is creative. They have health benefits. In short, it's good for you, so it's not covered by copyright. Another word for this is functional, and that's key in the trademark world because you can't trademark a functional aspect of anything. This means that Bikram couldn't even look to trademark law and say this is his trademark series of poses. I think the Copyright Office's decision makes sense. Yoga has been around for centuries, and so trying to copyright it would be like trying to copyright Greek myths or something. So now you know that when you're doing your Taibo workout at home, you can be confident that you are not infringing anyone's copyright. Baseball fans and DCers know that the Washington Nationals are having an amazing season. They're over 600. They have the best record in baseball, and they have literally been knocking it out of the park. They are not doing quite as well on their trademark for the curly W. They do have a trademark registration for this W on my Fansphere Advisor here, but it looks a whole lot like the W that the national pharmacy chain Walgreens uses. Is this an IP time bomb? Do the Nationals need to be really worried about whether Walgreens can sue them for trademark infringement over the similarity of their Ws? Well, Walgreens does have a federal trademark registration for its W, so do the Nationals. However, the Nationals didn't come back to DC until 2005, and Walgreens has been using its W since at least 1951. Also, Walgreens is not afraid to go after potential infringers. In 2010, it sued the grocery store chain Wegmans over infringement involving its W. Wegmans W is a little less similar, I think, to the Walgreens W than the Nats W is. That's a lot of W's, I know, but the pictures will help. So, do the Nationals have something to be concerned about here? Well, the main question is whether or not people are going to be confused. After all, the Nationals is a baseball team and Walgreens is a pharmacy chain. But the Nationals make t-shirts that have their W on it. They also might introduce a line of energy bars or sports drinks that have this W on it. If those get sold in drugstores, then Walgreens might be able to say, yeah, this looks too similar and people are going to think these are Walgreens products. So the Nats haven't won the game yet. A couple of things that might help the Nationals, though, is that the Patent and Trademark Office issued a federal registration to the Nationals for this W in 2005. So clearly the Patent and Trademark Office didn't think that baseball was too similar to pharmacies, that there would be confusion there. The other thing that might help the Nationals is that the Washington Senators were the baseball team back in the 50s and 60s. It's very possible that the Washington Senators used this W before Walgreens started to use it. So that would be an open question about who the first user of this particular design is. I guess we'll have to wait until the bottom of the ninth to see who wins on this trademark case. Okay, this next case is a great example of how not to rebrand to avoid trademark infringement. You may have heard of the outdoor activity gear seller, The North Face. They sell all sorts of coats and parkas and products that you can use if you are into hiking or skiing or rafting or all of those other fun fitness-friendly activities. Now, a few years ago, a college student decided that he wanted to start selling t-shirts and sweatshirts with the logo, the South Butt. It looked a whole lot like the North Face's logo. Now, you might think this is funny, but the North Face really did not. They decided that they would sue this young man for trademark infringement. He didn't take the case very seriously, but he did eventually settle with the North Face and agreed that he would not sell any more t-shirts that said the South Butt or other imitations of the North Face's trademarks or logos that might be confusingly similar. He also agreed as part of this that even though the South Butt is a reference to the North Face, it wasn't a parody. That's pretty important because in trademark law, a parody can be an exception to trademark infringement. Fast forward to just a couple of months ago. Turns out that the college student decided he would rebrand as the Butt Face with another pretty similar logo. The North Face did not develop a sense of humor over these 2 years and decided to ask the court to find that this college student had violated the terms of the settlement agreement. Now, the North Face just filed its motion asking the court to stop this young man from selling these t-shirts back in August, so we'll have to wait and see if the court finds this as funny the second time around. The takeaway from this case is that if you're really serious about developing your brand, develop something that's distinctly your own, and don't rely on an association with somebody else to generate publicity and just cross your fingers that a court has a good sense of humor about it. That's all for our first episode of ICIP. Thanks for watching, and I hope you'll come back next time.